I don't know. Going back to there. Hmm. What the fuck is this? Why is that on there? Hmm. Oh shit. I need to look at the uh,
Ladies and gentlemen of the courtroom, all rise for the Honorable Doc Hillard.
whoopsie.
All right, there you go.
Hey there.
I think y'all, everyone in the gallery may be seated, and I will ask the litigants to approach the bench. Thank you all. You may be seated. I will ask the litigants to approach the bench quickly. There is an issue that I need to sort out before trial. Mr. Tate, you all good?
Yes, Your Honor.
So at the last trial, the opening statements were provided. Do y'all want to provide the opening statements here again, or do you want me? I've already taken the notes, or do you want to waive the opening statements and proceed to the state's witnesses?
We could proceed just for time, if that's okay with Mr. Tate as well.
I have a slight adjustment to my. That's okay. I can just, I don't know, give it to you maybe. I don't feel like.
No, we'll if you have an adjustment, then we'll go ahead and do the opening statements again. Okay.
Okay. Sounds good.
Okay, fine.
All right, and that's all. And then I'm going to solicit pretrial motions, and then we'll begin. Okay.
All right.
All right.
Okay.
Thank y'all. All right. It's my understanding that there were some pretrial motions that were made. Are the parties still persistent in those motions? After my post on line 35 of the docket, there was a motion. I think there's a motion to dismiss. There's a motion to admit some evidence. There are a lot of things. I'll let the state go first if they have any motions to make.
Well, yes, Your Honor. I did want to bring up the pending motions that are currently on the docket, just to get those addressed first and foremost, and then one of them includes a affidavit from Sergeant Duncan Murray, and I just want to make sure he's excused from the trial. He was going to be called to testify, however, he's unable to make it, and he did provide a affidavit.
Okay, I was made aware that he was going to be unavailable today. That was through the scheduler, so I acknowledge that. As far as the admission of the affidavit, Mr. Tate, what do you think?
Sorry, I was whispering. Yeah. I don't really have any issues.
You don't have any issues? Well, the only issue the court has is that the affidavit was submitted post-discovery phase. Is there any reason you were able to submit the 4 other affidavits and Mr. Murray's was late?
I submitted it as soon as I received it.
Okay. Well, I will go ahead. I will summarily deny the motion to admit the affidavit simply due to the fact that it was submitted after the discovery period. So that's the first motion. Do you have any other motions to address?
I have added Miss Sammy West back onto this case. That's why she's standing here beside me.
Okay, I acknowledge that as well.
Oh, you did?
Hey,
I
Dark.
apologize. I didn't see.
Or I do now.
Okay. All right, perfect. And then additionally, we received just an hour ago the results of DNA that was tested at the scene at the time. It just came in today, about an hour ago. And so I have not had a chance to submit that to the docket. I wanted to bring that up here for the same reason as the affidavit that you've denied because it's late.
Okay, and likewise, that evidence, are you seeking to introduce that as evidence?
Well, I would have just to avoid a Brady violation, Your Honor.
Okay, I appreciate that. I will summarily deny that as well for the same reason as for Mr. Murray's affidavit.
Understandable, Your Honor. Thank you.
Any other motions by the state that are pending?
No other motions, Your Honor.
Okay, Mr. Tate, do you have any motions that need to be addressed?
Well, I filed for motion of dismissal of the case based on things that I've written in the docket. I don't really want to say it again, considering I was accused of mentioning it 3 times already. But I do, fairly believe that this case should be dismissed based on the fact that Mr. Dawson proceeded to once again fail to sign up on the scheduler. And I do understand that he was in the ICU and all that, and I feel terribly sorry for him. But at the end of the day, he was able to be on duty not even 20 hours later. So I just find it a little bit upside down that we're allowing him to get a continuance in this case when he is able to be on duty not more than 20 hours later from being in the ICU.
Okay,
And then I've been on bail for a month.
Okay, it's my understanding that Mr. Dawson was released from the ICU either shortly after the scheduler closed or just shortly before the scheduler closed. Is that correct, Mr. McKnight?
It's my understanding he was released from ICU about an hour prior to it closing.
Okay, and had you communicated with him to fill out the scheduler?
Yes, I did ask him to fill it out as soon as possible. However, after somebody gets out of the hospital, it's understandable that they, need to contact family, work, get their life back on, track after, being in the ICU. So I think replying to a scheduler and in under an hour is not would be a little bit unreasonable in those situations.
Okay. I also like to say that this motion has already been addressed. This is a redundant motion. It'll also be denied for the same reasons that I've denied the motion on line 35, but I'll reiterate for the public that it was denied because I felt that it did not cause an undue burden on the defendant, the court, the defendant, his attorney, and the state's counsel were in an email conversation discussing scheduling, and the court issued 3 different times that were with the most concurring availability for all the witnesses, and within the hour, all parties agreed to this date. So there was no, in my opinion, there was no undue burden on the defendant. Therefore, the motion is denied again for the same reasons on line 35. Mr. Tate, do you have any other motions to consider?
Yeah, I just want to mention as well, Ms. Hydra Dalton recused herself from the case, just for the record.
Okay, it's my understanding you are now first, second, and third chair.
That's correct. That's correct. Yep.
And are you comfortable representing yourself without her assistance?
Absolutely, sir.
Okay. Are those all your motions?
Yeah.
Okay, the court recognizes the change in the counsel and that you'll be representing yourself. I'll go ahead and begin with the standard preamble that I always do before the court, before the trial begins. We already have gone through you identifying yourself. The state has identified themselves. I will ask the state to inform the court of the charges again. It's my understanding there's been an amendment to the as far as the accomplice to robbery. So can you read the operative charges for the court?
Yes, Your Honor. The current charges are possession of an illegal weapon component, 1 count. Fleeing and eluding by foot, 1 count. Aggravated attempted second-degree murder, 6 counts of that, and it's split between the time and the fine, where there's also 1 attempted second-degree murder as well.
Okay. All right, I'll move on to informing everyone of the court's rules. To begin, both litigants are expected to maintain a high degree of professionalism. I hasten to remind both litigants only to address the court and not each other. That includes when you make motions and rebuttals and things like that. Everyone present for the proceeding will maintain respectful behavior and abide by courtroom etiquette. Those attending will respect the authority of the court and will comply with the court's instructions. I ask that all electronic devices must be turned off or set to silent mode. No recording or photography is permitted by those in the gallery except those explicitly permitted by the court. And conversation shall be kept to a minimum and conducted in a whisper so as not to disrupt the proceeding. With these rules established and with all the pending motions addressed, we'll begin with the state's opening statement.
Thank you, Your Honor. And I apologize to anybody who was here the other day. I haven't made any modifications to my statement, so you'll be hearing it once again. Your Honor, the defense, citizens of Los Santos who are in attendance here today, we are here today for the events that took place on March 16th of this year involving the defendant, Larry Tate. On the date of this incident, multiple officers responded to a Parks Department groundskeeper panic alert or a groundskeeper down alert in Grapeseed. They arrived, meeting a hailstorm of gunfire. The suspects on scene eventually fled in an Issy Sport, which was registered to defendant Larry Tate. Officers pursued this vehicle until the suspects swapped into a Pfister Astron, also registered by Larry Tate. The Pfister then fled into Vinewood Hills, where another shootout with officers commenced. 3 of the suspects were incapacitated and arrested, while a 4th fled on foot. Moments later, the defendant, Larry Tate, was found up the street from the Vinewood shootout near the Cypress Theater. He was GSR tested, which came back positive with high intensity, meaning there's a lot of gunpowder on him, and it was very fresh. Officers then searched the area along the route from which Tate was detained to where the shootout took place. Lo and behold, a pile of clothes with a firearm was found in a bush. The pile of clothes contained a Black Lotus MC jacket and a firearm registered to Mr. Tate. For those unfamiliar, Larry Tate is a well-known Black Lotus Motorcycle Club member. He is known to be the leader. In addition, the other suspects arrested were also known members of the Black Lotus Motorcycle Club. Officers went on to do their due diligence. They processed every scene this incident created. Dozens of articles of forensics evidence was collected. Fingerprints, DNA, shell casings, bullet impacts, you name it, they got it. So you must be wondering, was any of this Mr. Tate's? That is what we are going to dig into today. But spoiler alert, yes there is. Thank you.
Thank you, Mr. McKnight. Mr. Tate?
Well, apologize. My opening statement is a little bit long, okay? And there's also a lot of repetitiveness here as well. But you know, here we are, so I gotta get it done. Ladies and gentlemen of the courts, your honorable judge, Hilliard, we are gathered here today to address the issue of accusations made towards myself. On the day of this incident, I was out for my daily cardio. As you may or may not know, I live in Mirror Park. I usually do runs from Mirror Park down Vinewood Park Drive, past the casino, up Mardo Drive, up Bay Tree Canyon Road, and around the mountain through Mount Hahn Road. This allows me to get some good cardio in, but it also allows me to view some beautiful sights while at it. On this specific day, however, I ran towards what seemingly sounded like a hailstorm of gunfire in the distance. I didn't think much of it and continued my run up Bay Tree Canyon, to which a police officer pulled up to me, screamed at me, and told me I was being detained. Said officer is not here today, nor was he asked to appear in court or questioned whatsoever per the state's own records. I proceeded to ask why I was being detained, to which they refused to respond, but yet assumed I was involved with whatever incident they were dealing with. Now, let's look at the facts and the evidence from the police here, okay? Yeah, my vehicle was definitely on scene, but that does not prove that I was there. My firearm was supposedly found in a bush, to which I asked which bush was it found in, where exactly, and as the police considered to look at how many firearms I have purchased through my 3 years in this state. It is a violent state. Did either of the police officers put in enough effort or work to look into whether or not I've had said firearm available to me? Maybe I got robbed. Maybe someone had taken it out of my vehicle, in which I never drove that day. The state also mentioned a Black Lotus jacket that was found on scene. As the clothing designer, fashionista I am, I can put out right now that there is no such thing as a Black Lotus jacket. That does not exist. So I'm quite curious as to what jacket they're talking about here. Now we can go over and look at the forensics results of the bullet casings on the scene. I did a little bit of a dive through all of them, and I did not see a single bullet fragment or casing belonging to the firearm they supposedly found in a bush. Could it be that it was never fired? Who knows? Now, the police proceeded to detain me based on a GSR test I allowed them to take on scene. They informed me that it came back with high intensity. And, you know, that's fair. I can understand the police would assume and draw their own conclusions on the matter. Did the police ever consider to question me on whether or not I had fired my gun previously that day? No, they did not. Did I have a gun on my person when they detained me? No, I did not. Quite frankly, I had been at the gun range that day doing shooting practice in preparation for you know, maybe I was going out hunting some deer. You know, you never know when you're going to need your firearm. Anyway, they continued to draw conclusions, make assumptions, and drag me down to the station, where they told me that I had been shooting police officers, but I never did. Now, I want to cover the most recent evidence that was, submitted a day after Mr. Dawson's ICU visit. Something which I argued a little bit already, but I'm just gonna ask a couple of questions. I guess not really ask questions, but some blood samples was added to this docket. Why did it take PD so long to have these forensics results processed, considering everything else was processed in 48 hours? Why did it take 2 to 3 weeks to process a blood sample? Another question I had was, how fresh is the blood they allegedly found on scene? Because there's not really, maybe I've been there, partying at some point, and I scrubbed my knee, and the blood was on the floor, or on the road, maybe, who knows. The next thing is, to my knowledge, I was not injured that day, nor did any police officer check if I was injured or offer me medical assistance. And if you guys look at Exhibit A submitted by the defense, there's a picture of me in there. Could anyone here pinpoint exactly where I was bleeding, or how I was bleeding, or if I got shot or stabbed, or maybe I fell during my jog? Who knows? No one looked into that, did they? The fact of the matter is, I jog on Mardo Drive, Bay Tree Canyon, quite often. I could have been injured on a jog one day. I could have fell at some point, and the blood could have been there for weeks. Who knows? Now, during my time at the police station, they brought me into that room with the window you can't see through, but you can see through it. To have someone look at me. I can only assume that they, were trying to have some sort of witness confirm whether or not I was on the scene. But based on the evidence submitted, no one recognized me from that scene. Could it be that I wasn't actually involved? Now, to go over to the charges in which I'm accused of, such as possession of an illegal weapon component, as I stated before, I wasn't in possession of anything. I did not have a firearm nor a weapon component on my person at the time of my detainment. Then there's the fleeing and the looting. To my knowledge, once police pulled up on me at Bay Tree Canyon Drive, I stopped running to ask if I could be of any assistance, to which the police officers detained me. I did not at any point during that interaction attempt to flee nor run. I obliged every command given by PD. I don't think I need to cover the aggravated attempted second-degree charges, as I've kind of done that through this entire opening statement. But I am here to argue the charges in which I've been accused of, as they're not only lacking in evidence, but they're also lacking a full picture of their own officers' work. If I'm to be prosecuted for anything here today, it would have to be aggravating my own thighs during the uphill strain at Mardo Drive. Thank you very much.
Thank you, Mr. Tate. Counselor McKnight, Counselor West, so y'all may present your first piece of evidence or your first witness.
Thank you, Your Honor. One moment.
Ah, look at the streak, bro. Eh.
We're going to start out by submitting into evidence Exhibit A, the officer's statements in the full report.
The court notates that.
And then we're going to go ahead and call Deputy Benjamin Dawson to the stand, please.
Deputy Dawson may approach the bench and be sworn in.
All right, Deputy Dawson, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, your witness is sworn in.
Thank you, ma'am.
Stand over here.
Can you please state your name, department, and rank for the record?
Yes, sir. Senior, it's going to be Benjamin Dawson. Work for the Blaine County Sheriff's Office, and I'm a senior deputy.
And how long have you been in that position on the force?
Senior deputy, or in general?
In general.
Since I believe around the 5th of November.
And do you recall the case in question and your involvement?
Yes, I do.
So, how were you first notified of this situation?
Well, it started with a panic button from a groundskeeper, a ranger groundskeeper up in the Grapeseed area.
Whereabout in Grapeseed did this take place?
From my understanding, the panic button took place within Grapeseed, and then there was a subsequent shots fired on East Joshua Road just outside of Grapeseed.
And what did you see when you first arrived on scene?
Um, from my recollection, there was a vehicle leaving the area in the distance, and there was going to be one individual on the ground next to a dirt bike. That was going to be the ranger groundskeeper who had been shot down.
The state would like to enter into evidence Exhibit D8 through 12, which contains the groundskeeper shooting alert, photos of the crime scene, and evidence collected on scene.
The court acknowledges that.
Were there any suspects on scene when you arrived?
Not to my knowledge, no.
Were there any vehicles on scene?
None other than the vehicle that was leaving in the distance.
Do you know what vehicle that was?
I couldn't make it out, but officers reported a ISI Sport going southbound, which was later confirmed by the victim in this case as the vehicle involved.
And do you know the registered owner of the ISI Sport?
I believe it was Larry Tate.
And what did you do after the ISI fled the scene?
I secured the scene, put up barriers in the road while Deputy Rivera Finch provided medical treatment for the downed groundskeeper.
What evidence was gathered at the initial scene in Grapeseed?
It was casings and some blood and impacts.
The state would like to enter Exhibit F4, which is the photos of the groundskeeper shooting, into evidence.
The court acknowledges.
So, what was your role after securing and processing this scene?
Well, I was with the victim pretty much through until they went down to Pillbox. I then went to Triple SO to process a vehicle that was going to be brought there. It was going to be the ISI Sport. They had swapped vehicles, I believe, in the Grapeseed area. So the ISI was being brought to Triple SO so I could process it, and which I did.
Were you present during the Vinewood Hills shootout?
No, I was not.
According to the report, how many suspects were there?
4.
And do you know how they arrived at this location?
I believe they took a different vehicle.
Do you know what vehicle that was?
I'd have to double check. I'm not 100% certain.
Would you be able to find it in your notes, possibly?
Sure, one moment.
If it is okay with the court, if he reviews his notes.
That's fine.
It was going to be a Fister Astron.
And who's the registered owner of this Fister Astron?
Larry Tate.
The state would like to enter Exhibits C 1 through 4 into evidence. It's the photos and VIN of the Fister Astron.
The court acknowledges that.
Are you aware of any officers being injured in Grapeseed or Vinewood besides the groundskeeper?
Yes, I believe there was numerous officers that were incapacitated in Vinewood, none in Grapeseed though.
The state would like to enter Exhibits H 1 through 4. It's the medical reports of Duncan Murray, Austin Shepard, Paul Peter Clemenza, and Liam Kavanaugh, which show gunshot injuries sustained during the incident.
The court acknowledges.
Were you present during the scene processing in Vinewood?
Partially.
Do you know what evidence was collected?
Yes, there was gunshot casings, impacts, and DNA evidence collected on scene.
And were you the one who later ran those articles of evidence?
Some of them, from my recollection, I believe there was some ran by other officers that collected them. I could be wrong though. I'm not entirely sure. I think I did quite a few of them, but not all of them.
The state would like to enter exhibits E1 through 7 into evidence. It's the evidence collected on that scene.
E1 through 7.
Correct.
All right, the court acknowledges.
What did you do after the officer-involved shooting in Vinewood Hills?
I was tasked with searching the area for a fourth suspect that had fled on foot. When I arrived in the area, it was told that there was a suspect found shirtless. So I began searching around for anything that could have been ditched in the bush or anything in the area, as that's what criminals do a lot, is ditch evidence in bushes.
Are you aware of the exact location in Vinewood Hills where that shooting took place?
It's gonna be the cul-de-sac of Marlowe Drive.
And so roughly how far from the cul-de-sac and Marlowe Drive is where the suspect that was found shirtless on foot detained?
Couple hundred meters.
If we all look at our maps, could you kind of paint a picture for us?
Sure. The cul-de-sac on Marlowe Drive. If you look to the right of it on the map, where it's Marlowe and Baytree Canyon, where the little dirt roads is, on that exact corner on the northwest side, it's gonna be the bush that the items was found in.
And then kind of lead us to where the suspect was detained.
Suspect was detained at the I don't know how to pronounce that. Sisyphus Theater.
I believe it's Syphus?
Your guess is good as mine.
Syphilis? Oh. Are you sure? That doesn't sound right.
Oh, thank you. Syphilis Theater. Wait, that doesn't seem right.
Yeah, I don't think that's right either. I think they're messing with us. Okay, I appreciate that visual. Sorry, just let me get back on track here. And so how was the suspect ID'd that was picked up on the road?
One moment.
Yep, no problem.
Whoopsie. He could have objected to a lot of that. I want some snacks, man. I don't think there will be any objections.
Apologies.
No problem, Deputy. Are you aware of...
Yeah, I remember the question. Sorry.
Oh, yes.
He was initially identified via facial ID and potentially ID cards. I do not recall. I wasn't the one who was there and identified him, but he was then later identified in that day via fingerprints as 100% confirmation.
Are you aware if Tate was GSR tested at the time of detainment?
He was, from my knowledge.
And according to the report, what were the results?
It was high intensity.
And was he later GSR tested as well?
Yeah, he was GSR tested again quite a bit later in the VPD cells.
Can you estimate how large of a gap between GSR tests was this?
Ooh, I'm uncertain. I wouldn't be able to give you an accurate answer.
Under 5 hours?
Definitely, it was less than 1 hour, but
Less than 1 hour. Okay.
more than 25 minutes.
Okay. That's okay. I appreciate that. The state would like to enter exhibits F12, which is the second GSR test on Larry Tate into evidence.
The court acknowledges.
Looking at the docket on lines 7 and 11, was this what the defendant looked like?
One moment, please. Line 7, you said?
7
Oh,
and
right,
11.
I'm saying that. Okay. I believe that is the individual that was arrested, yes.
Thank you. And going back to where you talked about searching the area, did you find anything nearby?
Yes, I did.
What was found?
It was some articles of clothing and a firearm with an extended magazine. It was a heavy pistol registered to Mr. Larry Tate.
I appreciate all that. You answered the next 5 questions I had. The state would like to submit in evidence exhibits. Exhibit F10 is the Larry Tate heavy firearm test, and Exhibit G, the evidence locker, which shows the evidence that was found in the bush.
The court acknowledges.
What is the significance of the I believe I keep calling it a jacket, but what was that article of clothing actually?
It was a hoodie.
It was a hoodie?
Yes.
What kind of hoodie?
It was a black one with some writing on it.
What was the writing?
I'm uncertain at this time.
What were the other articles of clothing?
What'd you say, sir?
What were the other articles of clothing?
There was a vest.
The vest.
Yep.
So what did the vest look like?
It was a blue Black Lotus vest.
Do you see that in the courtroom today?
Oh, not presently. It was it wasn't a cut. It was a bulletproof vest.
Bulletproof vest. I see. Okay. In what way is Mr. Tate known to law enforcement?
As the leader of Black Lotus MC.
Are you aware how that information is known?
Numerous arrest reports, interactions widely known in, well, the entire state.
And then who ended up processing the DNA and ballistic evidence ultimately for this case?
It was a mix, I believe, of myself and Dave Mason and/or his cadet.
When the evidence was tested, were there any matches to Larry Tate?
Yes, we had a DNA match on numerous forensic reports from that incident that matched his DNA.
The state would like to submit into evidence the remaining exhibits for Exhibit F, which is all the swabs forensic, ballistic, and DNA tests.
All of the rest of the F exhibits, so that's F, you have to list them out for them.
Oh, hold on. F 2, 3, 5, 6, 7, 8, 9, and 11.
Okay, the court acknowledges.
One moment, Your Honor. No further questions. No further questions, Your Honor.
Okay, thank you, Mr. McKnight. Mr. Tate, do you have any questions for the witness?
Yeah, absolutely, I do.
You may approach the dais.
Hello, Mr. Dawson. How are you doing?
Pretty good. Could you put your
Something wrong, Mr. Dawson?
yeah? Could you put your arm down?
Are you saying that?
Just take a little step back, please.
Oh, why's that?
Just very uncomfortable smell right in front of your area right now.
Are you assuming that I smell, Mr. Dawson? Is that what you're doing right now?
Well, you see, the smell wasn't here when you weren't here, so I would say so. That would be my presumption.
Because you're assuming that.
Your Honor, could you ask him to step
I'm
back?
smelling.
Let's get very overwhelming.
Mr. Tate, you can question him from the podium. That's fine. Or if you would like to stand a few feet away from him.
Interesting.
Oof, oof.
All right, Mr. Dawson. I just want you to clarify something for me, okay?
Okay.
Did I hear right that you were not on the Vinewood Hills scene originally? Like when all the shooting and all that happened? You were not one of the responders, correct?
No, I was not at the shots fired.
Okay. So with that, did you at any moment of time see me on that scene during the shooting?
No.
Okay. And when did you first interact with myself, also known as Larry Tate? On that day?
In the cells of VPD.
In the cells of VPD, okay. So you didn't see me at any point before that?
No.
Okay. Could you inform me what I was wearing that day?
You were shirtless, wearing black pants with white writing on them.
Okay. Did you or any other officers contact me about a missing vehicle that day, or try and reach out to see if one of my vehicles had been stolen, or maybe 2 of my vehicles, or 3 of my vehicles?
No.
Okay.
We don't presume vehicles are stolen when they're not flagged for such.
All right, but when you find a vehicle on scene, do you not usually reach out to the owner if the owner is not present?
In due course.
Okay. And what evidence did you submit to forensics and all that for this case?
In total?
Yeah, you can just give me like a, small rundown.
Some just basic forensics, casings, impacts, blood, DNA, fingerprints.
Okay, so you submitted blood that day, is that correct?
I did
Objection, Your
indeed.
Honor. He's repeating his questions.
Sorry, oh, okay.
I'm just clarifying. Just clarifying.
All right, the witness already stated he submitted blood.
Okay. When did you submit the blood?
From the incident that I got,
Not the
or
Vinewood Hill scene.
are you looking for exact time? I mean, probably
Like day.
pretty shortly after the incident occurred.
Okay. And just to clarify, on that day I was GSR tested twice. Is that correct?
That is correct.
Okay. So with that, would you say there is a chance that I could have fired a gun earlier in the day prior to the shooting?
Anything is possible.
Mm-hmm. Okay. Anything is possible. That is right. Now I'd like you to go to line 7 in the docket again, if you could. There's a picture in there.
Yep.
Should say Exhibit A from the defense.
Yep.
Earlier, I believe you looked at this picture. Is that correct?
Yep, that's right.
Okay, and just to clarify, the individual in that picture, is that the same individual you guys are arrested that day?
From the looks of it, it probably is.
I'm gonna need a yes or no, Mr. Dawson.
I'm not 100% sure.
Okay.
I just simply do not know.
But probably yes.
Objection, Your
Probably.
Honor. Leading.
It is crossed.
I mean, that's what he
He's
just
on
said.
cross. The objection's overruled. He's on cross.
Right. Your Honor, I have a little bit of a strange request.
Let's hear it, Mr. Tate.
Can I take my shirt off?
Are you wanting to use it as some sort of demonstrative evidence for this exhibit?
Strip.
I just want to show the courts my current physical look, I guess, compared to the picture in the docket.
Is it in relation to your Exhibit A?
That's correct.
Okay, I'll allow it.
So, Mr. Dawson, if you look at the Exhibit A again, the individual in Exhibit A who you said that was probably the individual that you arrested that day. If you look at my stomach here, you can clearly see that I don't have a six pack. You know, I'm very strong, but I'm not that well built. So, are you not entirely sure of who you arrested that day?
I arrested you that day, Mr. Tate.
Oh, okay. Fair enough. Sorry, Miss West. I apologize. All right, I think that's all the questions I have. Thank you. Thank you so much.
Thank you, Mr. Tate. Mr. McKnight, Ms. West, y'all have any further questions?
Your Honor.
Yeah.
Oh, one second, Mr. McKnight.
That they did not see prior, and they're a bit unsure about it. So I don't know if you're aware if there was a duffel bag there ahead of time or anything like that, or if that's something we should potentially stop things for.
The judges leave their belongings in there. It's always there.
Okay, all right. Sorry, I apologize. I just trying to make sure we don't have a serious situation.
The first time when I first was a prosecutor, I thought it was a bomb. So
Okay.
I don't blame anyone.
All right, I'll let them know.
All right, thank you.
All right. Be advised.
I apologize, Mr. McKnight. You may redirect.
Thank you. W. Dawson, back to the GSR test thing, since it sounds like that was a point of controversy for some reason from the defense. When somebody is GSR tested, and they come back high intensity, from your professional experience, what is the time range for that to subside?
I haven't conducted a really great deal of GSR tests in the instance where they come back high intensity. So, all I know is it's very, very recently.
So if somebody was jogging, would they be shooting their firearm? Actually, disregard that question. Disregard that question. I'm trying to think how I can reword.
Come on, Mr.
No
Midnight.
further questions.
Mr. Tate, do you have any more questions?
That is unfortunate.
No, I'm good.
Okay, do you intend to call the witness,
Nope.
Mr. Dawson? Okay, Mr. Dawson, you are released from your subpoena. You can leave the court as you please. Thank you for your appearance.
Thank you, Your Honor.
The state may present its second witness or next piece of evidence.
The state's also going to enter into evidence, if we haven't already before, Exhibit B, the items that were found in the bush.
That has not been submitted, but the court acknowledges that.
And the state would like to submit the exhibits A, 2, 3, 4, and 5, which are the affidavits from officers Jake Scott, Bianca Johnson, Austin Shepard, and Dave Mace, who were also present during these events, and swear to the events that they witnessed and the injuries that they sustained.
The court acknowledges those exhibits.
Along with Duncan Murray's affidavit as well, which would be A6. Oh, I'm sorry, you denied that one. I apologize.
Yes, sir.
And then, so I guess lastly, we will be submitting exhibits I, 1, and 2, which are the DNA warrant and the results of that warrant, which shows the defendant's DNA marker.
Okay, the court acknowledges those two exhibits as well.
That is all that we have for witnesses and evidence, Your Honor.
Okay, Mr. Tate, you may present evidence. I don't recall a single list of witnesses you intend to call, or you can testify yourself. And if you do wish to do that, I'll instruct you how to.
I don't believe I have any further evidence to submit. I definitely don't have any witnesses. As I've mentioned multiple times, I was out jogging. I don't usually do that with people. Yeah, I think I'm good.
Okay. All right, the court will acknowledge that both parties have rested their case. Do the parties wish to have time to prepare their closing statements?
A 5 to 10 minute recess is probably fine for the state, Your Honor.
Okay. Mr. Tate, are you prepared?
I'd also be good with the 5 to 10 minute recess.
Okay, we will reconvene in 10 minutes, so that'll be 6:05. Court is in recess until then.
All right, if anyone's leaving, just be aware that you're going to be searched up again.
That was being fun.
Very short.
Yeah, surprising.
What do you think?
I have to review the evidence.
I mean, they got Benjamin Dawson to testify, but a lot of the stuff he testified to, he wasn't there for.
Correct.
Yes.
And overall,
The
I just
defense
was
did not be objecting.
No.
not objecting to it.
Many times he could be objecting.
Well, that's probably because he doesn't know. But we have to go with what was testified.
Not necessarily. We don't. If we believe that it's hearsay, you don't have to consider it as testimony from the first-hand observations.
Do the affidavits put Larry at the scene?
I think the only thing putting him at the actual scene is the DNA. I didn't read the affidavits yet. Let me look.
The DNA that was accepted, right?
It's on line up 31.
Give me more results. So we have one piece of DNA linking him back to the scene.
No, there was multiple DNAs found on the
Was
scene.
multiple?
Yes. No shell
Not-
casings recovered. Returning to the
not-
gun. Not specifically.
No shell. Well, I'm just saying one. There's a singular piece that links Larry to the scene, but there's a lot of evidence there.
No, there is multiple samples of that
Is there?
DNA
Okay.
in the reports. I do remember looking yesterday.
Not
Yeah, there
familiar.
were DNA samples, but no casings from that gun.
Okay.
There were some inconclusive, but no way to be telling.
Well, the batch of inconclusive 45 caliber casings came with some completed
Yes,
casings, and the
that is true.
microstamps were not
Not the
consistent
same.
with those. Yeah. And then one of the officers who requested the lab results on some of the DNA, Tal Grima, didn't provide any testimony.
He did not.
Why would they not get him to be the witness? Or at the very least, the affidavit.
Kind of strange as he's on duty. That's just my own 2 cents.
Then Anthony Grayson was another one that he requested a forensics report where Larry's DNA came back but never testified to it. And Tal Grima again. So, I don't know.
It's a lot of toss-ups to me.
I can't see this. Mm.
I may have the prosecutors go one by one on the attempted murder and tell me exactly who the charges are for, like the officers who they claim he shot. Because I can see here in one of the affidavits, Austin Shepard says that he was shot by a shotgun. And
I don't know why they did not argue the Crime Crisis Act.
yeah,
Well,
not only was Austin Shepard shot by a shotgun, but he's saying that Paul Peter Clemenza was shot by a shotgun too.
Is there shotgun casings recovered?
There were, yeah.
ooh, that makes it. Mm. And we're saying that Larry just had a pistol with attachments. Correct?
That is what they are asserting, but that gun did not return to any casings recovered from the scene.
And they testified that it's registered to him, but there's
But there's no cases.
well,
no
there's
casings.
not
There's
only
no
is there no
evidence of
casings,
the
but there's no
weapon
evidence that
registration.
yeah, they didn't take a picture of the serial number.
Oh my god.
I don't think they did a very good job.
No, it does not sound like they did.
I probably would have also submitted into evidence the search of each of the other suspects. Did any of them be having the shotgun?
I don't have a lot of how do I say this?
The fuck?
The evidence that the state provided, it's not really encouraging me one way or the other.
Oh, it's 5 past.
Uh-oh.
Where's my bailiff?
Oh my god.
I can't believe. No bailiff.
Alright, I guess I gotta do it.
Where the hell did my bailiff go?
I don't know.
What was her name?
Calliope?
Oh yeah, that's right.
If not, I'll rise court and now back in session.
Where are you? Oh yeah, we went to the field. Well.
They should.
Alright, we're
There's
ready.
a lot more evidence they should have put in there.
All rise for the honorable doc killer.
Thank you all. You may be seated. Are the litigants prepared for their closing
DNA on the
arguments?
scene is very strong.
The state is, Your Honor.
Yeah, the defense is as well, Your Honor.
All right, Mr. McKnight, you have the floor.
Thank you. The state would like to once again thank everyone for being here today. We appreciate the court's time in these matters and the defense's equal passion for justice as we do. Just to entertain the defendant in the court, the state would like to address an item Mr. Tate attempted to make a point of in his opening statement regarding his apparent issue that some of the officers are not here. The state would like to remind all those present here today that the defendant can also subpoena his own witnesses and submit his own evidence. He may try to play the ignorance card. However, he had professional legal counsel in his party for the majority of this case. Moving on. The state would like to summarize the facts and evidence from the case that was presented today. Outside looking in, I know there's a lot here. A lot of evidence, a lot of affidavits, numbers, letters, things of that nature. Let's break it down as simple as possible. We heard testimony from the main officer involved in these events, Deputy Dawson, who covered the entire picture of what happened during his investigation. We have medical reports for 4 of the 6 reported to have been shot and wounded in this incident, which shows their wounds from gunshot fire, which, as everybody knows, is a deadly attack, plus statements corroborating the last 2 who sustained injuries. Larry Tate is the leader of the Black Lotus Motorcycle Club, or at least a very prominent member of the organization. Other members of his gang were involved and arrested on scene, who later pled guilty to this incident. Tate's firearm was found in the area of the shooting in a pile of clothes that included a Black Lotus MC vest. 2 of Tate's registered vehicles are placed at the scene, involved in the attempted escape of the arrested individuals. Lastly, Larry Tate's blood DNA was found 5 times across 3 crime scenes that were created during the duration of this event. For those keeping count and for your records, Your Honor, that would be contained within Exhibits F9 twice, or F6 twice, F9 twice, and F11. From these DNA results, we can see he was not out for a jog, minding his own business. He was present during these shootings on Marlowe Drive at multiple points of the road. He was at the cul-de-sac in Vinewood Hills, again, where a shootout with officers took place. He was GSR tested when he was first detained. It was high intensity when he was first picked up. And then, again, medium intensity in the cells, not less than an hour later, possibly even less than 30 minutes later. This shows that if he shot his weapon earlier that day, either on his jog, before his jog, 2 days before his jog, He would not be high intensity at the time of being detained. He would have been medium or less when stopped by these officers. He fled these scenes, which is why officers found him just down the street, trying to, which is why he was charged with the fleeing and looting by foot. In addition, his firearm had an illegal attachment, an extended magazine. It is crystal clear that Larry Tate was involved in the deadly attacks against officers throughout the city that day. His involvement alone is enough for the Crime Crisis Act to take effect. Therefore, the charges against him are undeniable. The court must find him guilty on all charges and counts. Lastly, the state would like to remind the court that when Mr. Tate is found guilty, due to representing himself, providing oral testimony as his own defense, he has perjured himself, and the state urges the court to proceed accordingly. Thank you, Your Honor. The state rests.
Thank you, Mr. McKnight. Mr. Tate, you have the floor.
Your Honor, ladies and gentlemen of the courts. That was a fantastic closing by the state there. Many assumptions made. Throughout this trial, the prosecution has attempted to paint me, Larry Tate, as a culpable party in the tragic events surrounding the officer-involved shooting. However, I implore you to consider the evidence presented with a clear and impartial mind. The state's case hinges primarily on the presence of a pile of clothes and a firearm registered to myself at the scene of the incident. Yet these items alone do not prove my guilt beyond a reasonable doubt. The mere presence of these belongings is not indicative of criminal intent or action. It is entirely plausible that my vehicle could have been in that location innocently, and that the so-called Black Lotus MC vest could belong to anyone considering it's a mass production item, considering the explanation provided regarding my daily jogging routine. It is also imperative to consider some of these charges and how correct they are. If I did not have a firearm on me at the time of my arrest, how can I be guilty of having an illegal weapons component? When did I flee the scene? If I stopped to converse the moment PD pulled up on me jogging. Moreover, the prosecution relies heavily on the discovery of blood at the scene. However, this blood could have been present for an indeterminate period, as my jogging route frequently passes through that area. There's no conclusive evidence linking this blood directly to the evidence of the shooting, the events of the shooting. Furthermore, it is crucial to address the concerning delay in processing the DNA warrant results. As per Mr. Dawson earlier, he didn't really know when he submitted it. The state's failure to promptly provide this crucial piece of evidence casts doubt on the reliability of their entire case. The suspiciously prolonged timeline raises questions about the integrity of the investigation and the credibility of the prosecution's claims. Your Honorable Judge Hilliard, I urge you to recognize the gaps in the prosecution's case and to uphold the principles of justice and fairness. The burden of proof lies squarely on the shoulders of the prosecution, and they have failed to meet that burden. Therefore, I implore you to return a verdict of not guilty for myself, Larry Tate, based on the lack of conclusive evidence and the reasonable doubt cast upon the state's case. Thank you very much.
Thank you, Mr. Tate. Give the court just 1 second.
You will be not guilty. I could have did win this case, I think, though.
Okay, the court is going to solicit from the state briefly uh, the individual counts of the attempted murder. Can you identify the victims individually for the court to consider um, these charges? Who the attempted murder was violated against?
Yes, Your Honor. One moment, please. But the aggravated attempted second-degree murder is for the 6 officers. We've got the Liam Kavanaugh, Jake Scott, Paul, Peter Clemenza, Austin Shepard, Bianca Johnson, Duncan Murray, which were submitted with the affidavits and the medical records. And it's my understanding that those are the 6 counts for the time, and then the attempted second-degree murder is just for the fine. I just my understanding of how that comes out.
Okay, so that, from my understanding, that's a law enforcement mobile data terminal issue. So you're just pressing 6 counts of aggravated attempted second-degree murder, right?
Yes, I apologize, Your Honor. I guess that's my misunderstanding of how that works.
Okay. All right. The court will go into deliberation and will reconvene within 20 minutes. So maybe around 6:40 or so. But until then, the court is in recess.
Okay, are you going back into cells? Okay, you're going back into cells. Okay.
Red suit guy.
Yeah.
Red suit guy. Quick word. Just want to clarify that I'm not a part of a fucking gang. Okay? It's a motorcycle club. There's a big difference.
Oh
I
God.
don't care what law
Okay.
enforcement says.
Okay.
It's a motorcycle club. Okay. No problem. Don't do it again.
Well, they mentioned the Crime Crisis Act, but they did that after the trial had, or all of the arguments had concluded.
I usually do that in the closing.
Well, it would have been nice to know that to consider for my deliberation prior to the trial starting.
Mm-hmm. Is there?
But even then, they would have to identify him as a participating party.
And that's what we're struggling to do at the moment.
What do you think, Miss Sunny?
Yeah, this is very difficult. Is it enough for just DNA to be all over the scene? At the same time, Mr. Tate did not really articulate how did his DNA be getting there. He said, oh, maybe I tripped jogging. He didn't say I tripped jogging. He didn't say was it the dance party.
That is a good point. But the state, there's nothing pinning him there
With
until
the exception of the DNA samples.
correct. There's no
5
witness
times.
testimony.
Well, what testimony would they have? They did not identify him until after the DNA warrant.
Mm-hmm.
They suspect him. I guess they arrest him with reasonable suspicion.
You would think.
How would they be high-intensity GSR?
That doesn't help his case.
With no gun?
High intensity GSR, no gun. The gun that is registered to him that was found in the bush that, I think could be argued pretty strongly, he may have been in possession of. None of the tests come back to the microstamps from any casings at the scene. So which gun did he use? No one knows. But Austin Shepard testified in his affidavit that he and Paul Peter Clemeza were shot by a shotgun.
The other suspects, some of them charged with class 2 weapon. I don't know if you can consider that. It was in the report though. That was being submitted. Exhibit A. Let's see if this works. So the question is the DNA multiple sample, different locations. 6 Lower Hill on Marlow Drive, 9 Broadband, and 11 the cul-de-sac.
So
That would be 3 times falling and tripping on his jog.
maybe Ashford had a shotgun on him or her or whoever. That's in the Exhibit A.
Yes. Jackson Rivers, also class 2 position.
Where's that at?
On Jackson Rivers.
I see the charge. I don't see the pictures though.
Why would they not put that in the report?
Yeah, the only
When they
What the
have
fuck?
they have a pump shotgun. They have 2 pump shotguns and 1 sawed-off shotgun. 3 pistols. Then I presume this is going to be Larry Tate's, the heavy pistol. That's the evidence locker.
Yes. That would explain the 3 positions of class 2 firearms. Sawed off and the pumps.
Trying to find the picture that they took of Larry. Larry said something about them taking pictures of him, or maybe it was in Dawson's testimony that he testified that,
I think
that he
it
was not
was
bleeding.
correct.
I think they are asserting that they that's, to me that can be a very powerful argument. But I think he is asserting that he was brought into one of those interrogation rooms and had presumably some people looking at him, that he did not be injured, he did not seek medical, nobody offered him medical.
As far as the whole tattoo charade, I'm not going to consider that because he submitted the evidence labeled as Larry Tate current physical proportions. So he purported that person to be Larry Tate. So we'll just assume that that's Larry Tate.
That was strange. I guess he let himself go.
Yeah, he was trying to make Benjamin to look like a fool, I guess, for identifying the wrong person, but they're clearly the same person.
Yeah.
Then we have to consider the fact that the officers who submitted the forensics, where his blood DNA was found, no one testified to, as
Not
whether
even
they
the
submitted it.
affidavit.
They didn't submit
nothing.
it, retrieve it, or anything.
Can that evidence be considered?
I don't think we should, or I should. I say we're like we're all judges on the case. But what do you think, Miss Sunny? This is your first criminal case you've kind of sat in on. I mean, there's nothing saying that he shot. Hang on.
The only thing saying he shot is the high-intensity GSR.
Sorry, say that again.
The only thing that's saying he's shooting is the high-intensity GSR.
Yeah, but there's no one saying that they saw him shooting or that he. I mean, I can't reconcile the blood being there, but I'll be honest with you, that's really like the least concern that I have is the blood being there. I mean, that proves that he was there, but for the Crime Crisis Act, even if we consider the Crime Crisis Act, we have to prove that he participated. To participate, you have to be actively involved, not just there, but you have to be involved.
Did any of the affidavits say all 4 people were shooting?
I don't think so.
These affidavits really did not do much. No.
No, they mostly just testifying to, I was there, I get hurt. None of the forensic reports with Mr. Tate evidence DNA is being from Mr. Dawson. It is Grayson and Grandma.
We verified there was multiple class 2s. We were both shot down and waited for medical. We were all shot by shotguns. So either there's a missing shotgun, which is speculation, or with the facts that we have, there's no shotgun that Larry could have possessed.
It really did not help that none of the officers directly involved in the shooting was being present to be testifying to the shooting.
Mm-hmm. So Dave Mace's testimony doesn't say anything about how many people were there, so I'll mark him off the list.
Correct. Bianca Johnson says the vehicle was occupied ×4. Next, they got hit by gunfire. Her driver was shot down, which was Jake Scott. And that is all the thing. That is all that she has said
No, I
about
don't think so.
anything about it. Was there was ×4 occupants, and
What did you do to the working?
We got shot.
And she doesn't identify who shot. She just says.
Well, that is the problem, though. They did not. They could have described it, the person in this blue vest or the black hoodie, but they did not know or suspect until after the DNA.
Just before reaching the observatory, we collided with the suspect's vehicle, ×4 occupied. They opened fire after we had a collision, as well as on Duncan Murray. The driver, Jake Scott, was downed in the driver's seat. I was unharmed due to my vest. They could not get out of the vehicle, and they did not have visual contact with the suspects after Jake Scott was shot down. Then the story immediately skips to treating everyone at Pillbox, and then moved to VPD after everyone was treated at Pillbox.
Look at Jake Scott's affidavit. He says,
due to there
the-
being 3 of them,
due to there being 3 of them.
they rained bullets into our vehicle. That's not good.
That is the conflicting reports. 3 or 4.
Jake's same car. Bianca says 4, Jake says 3. Same car. Driver and passenger.
Whose memory would be being better? The person they both get shooted down.
Bianca was, I believe they said, took some bullets to the vest and none of them directly hit her, while Jake was incapacitated. So I would have to say the person who wasn't incapacitated, which leads us to 4. But we have to take it into consideration.
Is the DNA multiple samples on the scene, different locations, with a high intensity GSR, being enough for the conviction? If there are no officers to be testifying to him actually being present, the question on 3 or 4 suspects, no description of the 4th suspect, and no officers being able to be testified to the forensic reports, no affidavit from the officers they running the evidence or document the scene. Is that being enough to be convicting him?
I don't. There's a whole bunch of saying that Larry should not. I don't think he should be charged for any of the attempted murders. There's some saying they were all met by shotgun fire because they all jumped out of the vehicle.
Am I thinking he is guilty? Yes. Am I thinking there is enough evidence? Absolutely not.
Yeah, I don't
There
think
is
so.
being too many holes.
Too many holes. We have Austin Shepard saying there's 4, so there's 2 people saying there was 4. However, they can only recall Mr. Rivers and Navy Ashford.
Let me look at the report.
Okay.
Um. Let me seeing 4 suspects. The female was already being down before they fleeing the scene. So that could explain the jigsaw discrepancy, but does not really matter. Jack Sanchez is the one GSR testing him, not testifying.
There's no picture of the GSR test, right?
No, there is.
The first one?
Is there not?
Forensics, Raw, Issy, Astron, Groundskeeper, Forensics, Lower Hill, up. There is
No,
no
only the
first
second
GSR test, only the second.
All the other suspects also high intensity GSR. I don't know why they did not DNA test the clothing they were covering.
They did, but they just got it back like 2 hours ago.
Oh, that is unfortunate. I can only assume who that's returning to. This statement in the report from Liam Kavanagh is asserting that John Gipp is asking where Larry was and if he was okay.
Who was?
If only they're having his affidavit to testify.
Who was asking
It
if
is in the police
Larry was
report.
okay?
It was John Kemp.
Interesting.
I don't want to find him not guilty, but why not affidavit from Zach Sanchez?
I wish I knew the answer for you, Sonny. Seems like that would be the person you would want to have an affidavit for, no?
And Leon, there's many things that is missing. Is it that being in the report statement enough? I don't know.
Okay, I think I have a little speech prepared. I'll have to supplement it in the written verdict, but I'm thinking
Not
to
guilty.
acquit him on the charges. We'll start off with the undisputed facts. You know that it was his car. He's not disputing that fact. His blood was found on the scene. However, the officers who collected that blood, processed it with the crime lab, didn't testify to it. Didn't testify to the retrieval of the blood. Didn't testify to the submission of the blood to the lab, and didn't testify to retrieving the forensic report. The fact that his blood is on scene, the fact that he was up the road in the area did not necessarily mean that he participated in the crime. I would talk about, just like I did in the Elsie Shaw case, talked about participation. You have to take affirmative steps to be involved, not just, be in the car. And you know that.
Yes.
But, we'll say hypothetically, if he was in the car, does that constitute participation? But I can't reconcile the high intensity GSR. I don't know. I mean, they try to get Benjamin to talk about the GSR. I don't know anything about how GSR tests work, how long it takes for it to downgrade from high intensity to low intensity or medium intensity. But frankly, that's not up to Larry to make that argument. It's up to the prosecutors to make the argument. Larry doesn't have to say a single solitary word if he doesn't want to. So
There is being a lot of things that they miss so many holes.
the fact that their witness, Benjamin Dawson, wasn't on the scene, but he testified to some facts that he doesn't have firsthand knowledge of, such as, there were numerous officers incapacitated. The shooting took place in a cul-de-sac. He wasn't there to participating in it. That's just according to the statements in his report, which I would say is hearsay. Whether or not it's objected to, I think is irrelevant. I won't consider that testimony. So I'll try to get through the verdict without stumbling, but I'm sure I will.
I believe in you.
But do you disagree?
No, I do not disagree. I think there's a lot more work that could and should have been done.
And there were remedies for the state to take. They could have dropped the charges. The case could have been dismissed without prejudice at some point. They could have opted to refile. They didn't do that. I'm not going to say that, of course, but there were ways for them to get the evidence in time before the trial started. So, all right, Mr. Clerk, are you ready? You have your audio recorder ready?
Yep.
All right. Let me get my ducks in a row, and we'll be good.
Oh my god, I am nervous. I don't know how.
All rise for the Honorable Doc Hillard.
Oh my god, thank you.
All right, good afternoon. First and foremost, I want to state that the court has had the pleasure to preside over the case, and that the allegations in the complaint are very serious. We're speaking of multiple attempted murder charges with aggravated circumstances. Those are very serious crimes in nature. But I want to start off with the undisputed facts of the case. The fact that the groundskeeper was shot initially at the scene in Grapeseed. I've seen the photographs of that. That is undisputed that he was shot. The fact that the vehicle, the Issy Sport, that fled from law enforcement from that scene is registered to Larry Tate is undisputed. The fact that the suspects in that vehicle fled into another vehicle, the Pfister Astron, which is also registered to Larry Tate, that fact is undisputed. The fact that Mr. Tate is a prominent member of the Black Lotus Motorcycle Club is undisputed. The fact that the other three suspects were wearing the same attire is undisputed, or were at least members of the club. The fact that Mr. Tate was found within proximity of the shooting scene is undisputed. The fact that he was GSR tested, according to the report, with a high intensity GSR result, And the fact that Mr. Tate had a registered, a heavy pistol registered to him that was located in a bush nearby is undisputed, along with some articles of clothing, all undisputed. But when considering to adjudicate the defendant guilty, the court has to consider whether the state proved beyond a reasonable doubt that the defendant committed the crime. And to commit the crime of attempted second-degree murder with an aggravated circumstance, you have to take steps to, pardon me one second. You have to take steps that can cause actions that would be expected to intentionally and unlawfully cause the death of another person without premeditation. The state brought up the Crime Crisis Act, which I think is very important to the case. And the Crime Crisis Act states that any person with a certain amount of people or more can be charged for the same crimes as long as they actively participated in the crime. Can be charged with the same crimes. To actively participate means to take affirmative steps to commit the crime. And today, the court has seen no evidence that Mr. Tate actively and affirmatively took steps to commit the crime of aggravated attempted second-degree murder, that he was in a possession of a firearm that was used to further the crime. And there's a lot of inconsistent testimony testimony in the affidavits. There was an officer who said that there were 3 suspects in the Fisher Astron, while there were some other officers who said there were 4. There was one officer who said that just 3 suspects shot at them from the Fisher Astron, and there were some that just plainly didn't say how many people shot at them or provided descriptions of them. The court does have a hard time reconciling how the defendant's blood was on the scene, but the court must also recognize that the samples collected on the scene were done by officers and processed in the crime lab by officers who did not provide testimony to the validity of the evidence and the security of that evidence. I don't recall the names of the officers, but I know that their testimonies have not been provided in this case, and therefore that evidence will not be considered. The fact that Mr. Tate's heavy pistol was found in a bag nearby where he was detained does not constitute for me possession of the gun. And also that gun, I hasten to add, the casings performed by one of the officers who did the ballistics testing, none of the microstamps came back that's positive on the scene of the crime as well. So it leaves the door open that Mr. Tate, that obviously that gun wasn't used in the commission of the crime, but if that gun wasn't used, then which gun was? And the court also can't reconcile that and how he would have taken steps to commit the act of attempted second-degree murder with an aggravated circumstance. And along with my previous statement, I don't believe that he was in possession of the gun from the evidence provided just by being in a bag nearby his detainment, along with the BLMC articles of clothing. As far as the fleeing and eluding statute that Mr. Tate is being charged with, if the court is going to adjudicate the defendant not guilty of the crimes of aggravated attempted second-degree murder, the court can also not charge the defendant with fleeing and eluding by foot. Therefore, the court adjudicates the defendant not guilty for 1 count of possession of an illegal weapon component as filed in this case. The court adjudicates the defendant not guilty of fleeing and eluding by foot. And the court adjudicates the defendant not guilty collectively on all counts of 6 counts of aggravated attempted second-degree murder. And it is so ordered. The court is adjourned.
Thank you, Your Honor. Appreciate it.
Shit, dude. Start
Excuse me.
peasants.
Lawyer. Get the hell out of this goddamn courtroom.
Is there anything else y'all need from me?
No, I don't think so. Just to make sure everybody getting out of here. Can you be hearing me?
Okay. All right, I am. All right, we're all good.
My God, so well spoken.
Shut up.
No, it was.
Bullshit.
Use the word reconciling a lot.
Yeah, I like to use that word.
This is very.
It's a good word. It's a good
yeah,
word.
good word. I'm going to take it. Oh my God. I wonder if I can use the word moist in my rulings.
You can use whatever you want. That's the pleasure of being a judge.
I will have
Ain't
to
it?
be creative for this. Then that is the right decision. The correct verdict.
You do?
Yes.
Good deal.
Hey, Doc.
Mm-hmm.
Hydra wants to speak to you about the bail amount because it
Okay.
was never listed.
Ms. Dalton, it's a pleasure to see you. I got your email. I'm sorry I haven't had a chance to respond.
Good. Hold on one second. Anyway, so on the docket, it was never listed how much bail that Mr. Tate paid. So I'm trying to do his asset request for him, but I don't know what amount to put.
Let me look it for you real quick.
Yeah.
I was gonna say I can probably look in my bank,
you
maybe.
could, but I'd rather it come from like MDT or court records, so that way, like, it's validated. And we don't have to send them screenshots of your bank account information stuff.
Was your
Right.
the person who issued your bail, was it esteemed Judge Tobias Torps?
I believe so. Yes.
Okay. It is $20,575.
Okay, one more time, because
Yes, ma'am. $20,575.
575. Okay, great, awesome. Thank you so much.
Yes,
Also,
ma'am.
I sent you a text message, sir, and you did not answer me back.
You know, I feel so bad.
Low key offended.
Well, are you prepared to be offended even more? No, I'm just kidding. We actually have an office building now.
Yeah, I know, but my office is way cheaper than your office probably is, because you
Yeah,
gotta
but
pay like at least minimum 10 grand a month. in
We
just
are
rent.
millionaires. We're swimming in cash right now.
Well, you know what? You could be even more millionaires if you bought my office and you paid less in rent.
Can I buy it as an individual?
Yeah, I don't care.
Like, I don't have to have a business or anything?
Well, I think you have to have a bit. It is like a donkel premises.
Actually, we're about to start a second business, so what I'll do is I'll register it in my name, and I can buy your office from you under that new business.
Excellent.
When did you show up? I didn't see you. Or it must be the hair, because you had
At the
different hair the
very
last time.
end. No, I was busy out of state doing some stuff, and I came for like the butt end of this. I didn't even hear closing though, so
Oh.
yeah, that's why I recused myself, is because I wasn't gonna make it.
And then your other email, do you still need the DUI arraignment?
I also reached out to Judge Clarkson, and he said he could get it at 5 p.m. I don't know that he did though, so let me double check. Otherwise, if we could get that sorted too, that would be great. I know that in Indigo, Skull is not around currently, but he will be waking up soon. He phoned me and said that if we could get his plea process, that would be great.
Okay. Yeah, if you said he'll be all around in a little bit.
Like within a few hours, yeah. If like the plea is accepted and everything, then whenever he is awake, we can reach out to DOC or law enforcement to see if we can just get him released, or well, not released, but at least like get him underway.
Right.
Is there any way he has like the option for some time served? since he's been in there since at least the 1 a.m. storm last night.
Yeah, I actually got a call about it from is Chase Reed the arresting officer?
I don't. Chase Reed.
No, he's no. This was a couple days
Isn't
ago. I'm
he
sorry.
like?
Never mind.
Okay, I was like, isn't he like a ranger or something?
Yeah. Is this a separate
I did
person?
talk to some rangers last night, but they contacted officers for me. I think Sophia Ramirez, and I think she had like a cadet with her, was like the arresting officers.
Yeah, I could. I can go ahead and process it. Let me get the verdict up. That'll take me I don't know, maybe 45 minutes to write. Yeah, I'm very. Yeah, I just like to type. Just hear myself type.
Hey,
So,
you know, it's a lawyer judge thing. Okay, we can
It is.
relate there. I'm gonna send you. Well, actually, I've already emailed you the link to the docket. But yeah, if you could handle that at some point tonight. If not, I'll try and catch the Chief Justice and get him to do that. But that would be super
ma'am.
if we could get him squared away.
Yes, ma'am. I can do that. And as far as the office goes, have you told anyone else about it?
No, sir. You were the first that I reached out to because I know
Okay.
that you and the Chief Justice were interested in the first time.
Yeah, I'll register the business, and then when I get can I actually get it like as soon as I get the business, or do I have to wait the period of time?
Well, I've had it for quite some time, so the transfer shouldn't really. I don't know how long it takes for them to transfer stuff, but I should be able to submit it like pretty right away. I don't know how long you have to wait for premises, or if we can inquire with DOCL
I think it's
what
30
that timeline
days.
looks like.
Um,
Yeah, for if you were like applying for one, like just not even buying it from somebody or connected to somebody.
Oh, it's like a
but
new
if it-
one, kind of.
Yeah, if it's a new one, I think if it's like in a pre-existing one and like there's a transfer of premises, like it might go a bit faster. But we can ask
All right,
about
I'm gonna
it.
step outside.
Okay, I
Okay.
will.
You guys have a good one.
Yes, sir. You too. Yeah, I'll ask about it, and I'll email you back.
Okay, I'll let you know when Indigo Skull is about. Then we'll do that. But
Okay.
thank
Yes,
you
ma'am.
for your time. I appreciate it.
Thank you so much.
Congratulations on being magistrate, Miss Sunny Day Kavanaugh.
Oh, hey there. Yes.
What's
You
it
know-
called again? Is it magistrator?
Yeah,
Or
Your Majesty, Raider.
Majesty Raider? That's right.
Majesty Raider. Okay, I will try and remember that.
Yeah, Majesty.
Majesty works. All right, you guys have a great evening.
You too.
Bye, Jay.
Okay. I think I'm gonna take a nap in the chambers.
Ah.
But hope you liked the case.
Oh, yes.
Uh,
It
yeah,
was not as straightforward as I thought it would be.
No, a lot of nuance to it, and that's typically what happens with all my cases. But do you have any questions, like about what I did or how I did something? Or I know you were a little concerned about addressing motions. I think I addressed some motions on the spot pretty quickly. Or objections. I also did objections.
There weren't really any objections
There were like two.
articulated in the case.
So the objection where he asked him to clarify the question. Typically, I would allow people like clarify, but he had
Literally
already.
just said.
He said blood.
We
and
said
he-
DNA, but that is. I
The
guess
same thing, whatever.
it's the blood.
So I sustained that objection and told him to move on. And then there was another one that I overruled. Do you remember what that one was?
No, not exactly.
But it's really just getting to learn your objections, and it all just comes down to really common sense. As far as the motions, so what I did on this case is they had made several motions literally just a few hours before trial started, 24 hours before trial started. One was to introduce evidence, one was to dismiss, and I wasn't going to make a ruling on them until the trial came in person, the people came in person. So that's just how I do it. Because I knew I was going to deny the motion for the new evidence and then the motion to dismiss. He made a motion to dismiss about 37 times, and I
Yes,
denied them
I
all.
did see that.
So As far as the evidence, that's on the state to get it within the prescribed discovery period. What is your discovery period going to be? Is it up to 24 or 48 hours?
I would prefer 48.
So I do the 48 just to give people time to prepare for trial, because I have seen it in the past where, like, literally the 11th hour they'll post like a bulk of information, a bulk of evidence, and then the continuance is requested. And if you actually look at the speedy trial act, there's an exception for like spontaneous evidence or like a lot of evidence being submitted at the end of discovery. So I like to do it 48 hours because it gets everyone time prepared to prepare. It gives the defendant the time to create an adequate defense. And as far as the opening statements, were you there for that when I asked them if they wanted to do their opening statements again?
Yes.
So Bert didn't want to. Larry said he had some edits to his that he wanted to do, so that's why I entertained it. I allowed them to do it again.
Oh, it is right here.
Luckily, his wasn't
Make
too
it
long, so it wasn't a waste of time. Anything else?
No. I think it is important to consider what evidence he testified to and who is being present to testify or affidavits. At least to testify to the evidence, not considered if nobody to testify to it.
Yeah, there's a lot of the cases that come to the court, like when people plead not guilty, there's a lot of nuance to it, and you have to make decisions. And I'm getting more comfortable at it. But like the Katarina Graves case, you were on that, right? That was your case?
Yes.
Like that, there was a lot of nuance to that, and it was very difficult for me to make a decision, but I ended up making one. And then you have about 20 minutes to make a decision. So typically, I don't know how you're going to do your cases, but what I do is like on this case especially, as the evidence comes in, I'll look at it, and I'll take notes, and I know you like to take a lot of notes too. Like you like to take 20 pages of notes.
Maybe.
But you can get a feel for how the case is going to go, and you can get an idea of how you're going to rule. So I knew going into this that there were going to be some pieces of evidence that weren't going to be testified to, and therefore couldn't be authenticated and won't be considered. So I knew like that was going to be an issue. And then I also try to prepare for any like motions or objections that may be made. Mr. Tate didn't make any objections for some reason. He had many good standing to do so. But I digress. But this is just one of those cases where it's just one witness and everything else is affidavits. So it's relatively easy. But anyways, Fallon Garcia responded to that expungement, talking about the Annie Wren character statement being locked. So what I'll do is instruct her to unlock it, and that'll be it.
Yeah, I saw that.
And I doubt they'll move it to a hearing. They never do.
Yeah, probably not. They did one time. They're very, very wanting to contest one expungement. Don't remember who.
Yeah, the
lawyer.
Yeah, Albie.
Yeah.
Yeah. And then in the middle of so we had like a PTC kind of thing, or like a pre-hearing. And in the middle of that, they said, we're not going to contest the expungement anymore. And they said it at the end of the hearing, by the way. So the hearing lasted, I don't know, about 30 minutes, and they said at the very end that they're no longer going to contest it.
Well, that was a dumb hearing.
Yeah. So, all right, are you going to stick around, or are you going to go to sleep?
I'm probably going to go to sleep. I need to get some rest.
All right, well, I'll see you when the sun comes up, I guess.
Yeah.
If it even comes up tomorrow, we'll see.
Oh yeah, I need to run.
For you at least. I don't know if you're going blind or something, but all right. You have a good day.
I don't know why. I'm going to go sleep in the other room. I'm going to go in here to sleep. Alright, I need to go and rest my balls. I get them laser today. So I am going to go just short stream today. Interesting court. I think I would have also found him not guilty. I would want to find him guilty, but you have to be not guilty based on the evidence and lack thereof. I don't know, there are so many things they could have and should have did. I don't know. But I need to go to sleep. Of the above average night, of the sunny day. Morgan. I don't know where she went. Oh, look at this shadow. Let me see. Where's this other window? Please find somebody to vibrate before we going. Let's go to here. Anybody streaming? What? Well, let's try it this way. Reading, maybe. Maybe anybody? Ah, Jails. Let us read him. I don't know what they're doing, but we're reading. Reading. Good night. Bye.